Assistant City Manager Michael Jasso. Go ahead.
Sure. Well, thank you, Darren. And to all the residents of Sacramento and our businesses and our property owners, welcome to the first in a series of webinars that the Office of Innovation and Economic Development will be presenting to give you more information as we navigate this time of crisis and COVID, but also beyond about programs, policies, kind of points of information from the Office of Innovation and Economic Development and how it affects our residents, businesses, and property owners alike. So this first one is focused on our temporary moratorium on commercial evictions that was passed last month by the City Council in light of the COVID crisis. And we are joined by a number of individuals, both from within the Office of Innovation and Economic Development, but also from our city's attorney's office. Joining us today will be Cheryl Patterson, Senior Deputy City Attorney, Danielle Foster, our City Housing Manager, and Tina Levote, who is the Program Manager for both the tenant protection program, but also the moratorium on commercial and tenant evictions. So with that, I would turn it over to, I think, our first speaker, and I will look forward to seeing you on the far side. In the coming months, we will have other presentations, and hopefully you'll find this a useful platform for which to get information from the city as we move forward. Thank you.
Okay. So, just again, my name is Tina Levote. I am a program manager with the Community Development Department, and I oversee the Tenant Protection Program, as well as the recently enacted moratoriums for both residential and commercial tenants. So for today's agenda, we're going to kind of do an overview of the moratorium. We're going to review some of the frequently asked questions. Cheryl's going to assist us with going over some recent state and judicial actions. And then we have some questions that were brought to us, so we'll go through the questions. We'll talk a little bit about surveys that we have going on, and then some local resources related to COVID-19. So March 24th, the City Council established a temporary moratorium on commercial evictions. And this is very similar to a moratorium that was placed for residential tenants. So it's consistent with the governor's orders, and it's scheduled to end on May 31st, 2020. For this moratorium, rent is defined as payment for use and occupancy of leased space. So there are a lot of questions like that, so we just want to make sure that people understand that this includes common areas or CAM, utilities, and any other monthly charge that's owed to the landlord. And tenants have up to 120 days after the expiration of the order to pay unpaid rent. And we want to make sure that it's very clear that what this is, it's delay in rent payment, it's not relief from rent payment. So tenants are still liable to pay any unpaid rent. So the commercial tenants who are protected are those that have had some kind of loss that's related to COVID-19. So it's either related to a place where a shelter-in-place order where they needed to close their business, or any other declarations related to COVID-19. And it's due to a loss in business. So there are some things that tenants have to do to be able to access these protections. They're not automatic. So one of the things that's really key and most important is that they really have to notify their landlord in writing prior to the day that rent is due, that they're unable to pay their rent. And again, it's really important that they provide documentation. If tenants fail to provide documentation, they are not afforded these protections. Tenants should also pay as much as rent as they can. They should pay a percentage of rent based on what income is available to them. So if they have any income that's available, they should really make an effort to pay some amount of rent to their landlord. And again, they don't have to provide the documentation when they submit the notice, but they do have to provide some kind of documentation eventually to be afforded this protection. So here are some of the frequently asked questions that we've received. So the first one is, do they need to provide the city with any notice? The answer to that is no. The city has provided a form that folks can use, and it's available on our website. There'll be contact information at the end with some links. But they don't have to provide that to us, but it's critical that people get that directly to their landlord. And we want to clarify that because our office have received a number of those forms, and it's really important that we advise people to make sure they get it to their landlord, because without that, they don't have the protection. In terms of the documentation that they should be using, It should be something that provides evidence of loss, either something that shows they've complied, a reduction in the hours of operation, any cash receipts that they have available that can show from prior months to the current month that they've had a loss in revenue. They should notify their landlord. Another question is, how often should they notify the landlord? Throughout the order, for each month, if there's a delay in rent, they should accordingly give notice to the landlord. So it's for every month that they're unable to pay the full amount of rent. A key question is, when must the rent be paid back? So tenants have up to 120 days after the end of the order to pay the rent. So right now, the order is scheduled to end May 31st, so they have until September 28th. One thing that's really key to note is that during this time, no late fees accumulate, so no late fees will be owed. So what if the tenant was already delinquent prior to the ordinance being adopted? They're not afforded this protection. So this can't be an excuse or reason why a tenant who's already delinquent, they can't use this to be further behind in their rent. But can a landlord increase the rent during this time of the state of emergency? The answer to that is yes. Neither the governor's orders nor the ordinance prohibits a landlord from increasing the rent at this time. If the lease should expire during this eviction period, then they're not obligated to renew the lease, however, it become a month-to-month tenancy. And the landlord must still provide tenants with the required lease termination notice and comply with all other state laws and regulations. So what happens if the tenant is unable to fully pay the unpaid rent within the 120-day notice? Well, the landlord can evict the tenant because, again, it's not relief in rent, it's a delay in rent payment. So the landlord can collect that rent. The tenant is still liable for that rent. However, since they have 120 days afterwards to pay it back, plus in another 30 days after court proceedings commence, they have a little extra time. So if there is a breach of lease based on unpaid rent, there is a little bit of kind of wiggle room for landlords and tenants to maybe try to work together. The landlord must still comply with all the regulations for a 3-day notice to pay or quit before they can even start the eviction process. So we're really hoping that this process isn't just seen as a way for tenants not to pay rent or looking for landlords to evict. We're really hoping that it's an opportunity to have some communication between the landlords and tenants to try to work out some kind of repayment plan. And that kind of goes to the next question. Is the unpaid rent amount the tenant should pay set by month? And no, it's not. It can be paid maybe on some kind of month-to-month basis following the 120 days. But it's really up to the landlord and the tenant to come up with some kind of plan or some kind of process for how they want to work together to make sure that that unpaid rent is paid. So I'm going to go ahead and toss it over to Cheryl, and she can address some of the state and judicial actions that have happened recently.
For the actions at the state level regarding eviction moratorium and how those actions affect the city's ordinance. The governor's order issued on March 16th allowed local jurisdictions to exercise their police powers to impose limitations on evictions due to the impacts of COVID-19 on loss of income. This order is in effect through May 31st unless sooner terminated or extended. The city's eviction moratorium ordinances for both residential and commercial tenants were adopted in reliance on the governor's order. On April 6th, the Judicial Council went a step further and adopted emergency rules of court which prohibit local courts from issuing a summons on a complaint for an unlawful detainer. This rule is in effect for 90 days after the governor declares that the COVID-19 state of emergency is lifted. If that occurs on May 31st, then the soonest date that an unlawful detainer summons can be issued is Monday, August 31st. As Tina mentioned, though, under the city's ordinance, tenants have an additional 30 days, or a total of 120 days, to pay the back rent. That means the landlord can't start an eviction process any sooner than September 28th if the eviction is based upon failure to pay rent. I believe now we're going to have questions and answers with Danielle.
Yes, thank you, Tina and Cheryl, for going over the moratorium. Now we have some questions for the panel. The first one is, what documentation is required to demonstrate loss of business income under the moratorium?
Well, really, one of the things that you could have an owner provide is a statement where they sign, where they kind of state clearly that they closed their business as a non-essential business in accordance with the public health emergency order, maybe something that shows a reduction in their hours, or again, being able to show cash receipts from previous months that show that loss of income.
Great, thank you. The next question is, what are the responsibilities of both the landlord and the tenant? What are they required to do under the ordinance?
Well, the landlord basically can't evict the tenant during this time. So if anything is related to COVID-19, they can evict the tenant, but the tenant also has responsibilities. And their key responsibility is making sure that they notify the landlord at least the day before, that there's going to be a delay in rent. And really, we really encourage them to do it sooner, because the sooner they can let the landlord know that there's something happening, the sooner they can really work together to address how they can continue to have the tenant be able to stay in the facility.
Great. Yeah, you keep highlighting the importance of communication. The next question is there a threshold for loss of income in order to qualify under the moratorium?
There isn't really a threshold, so there's not a certain percentage, but the tenant should pay a percentage of rent kind of based on the percentage of lost revenue. So for example, if they lost 50% of their income and they maybe have a mortgage or a rent payment of $10,000 and they've lost 50% of their income, they should pay 50% of their rent. So they should try to pay about $5,000. Again, it's really key that tenants pay as much as they can, because what they don't want to have happen at the end of that 120 days is to find out that they have to pay back full month's amount of rent at that time. So the more they can pay as much as they can, within reason for their other operating costs, the better.
Great. And then the next question is, who determines the validity of documentation provided to demonstrate the COVID-19 impacts?
So Cheryl, do you want to take that one?
Sure. Yeah, that's really going to be an issue for the courts and lawful detainer eviction proceeding, whether or not the tenant complied with the ordinance in terms of providing notice as well as providing the documentation. But the city does not have any kind of administrative procedure to evaluate documentation and make a ruling on whether it's sufficient or not.
Okay. And then the next question is a few parts. The first one is, what is the recourse if tenants fail to provide documentation to their landlord of the COVID-19 impacts?
Well, to be protected by the ordinance, the tenant's required to provide documentation. So tenants should really be prepared to provide some kind of proof of loss of income. It's simply not enough to turn in a form or send an email to the landlord simply saying, I can't pay my rent. They really need to provide some level of documentation.
And then the next two parts are, what is the recourse if landlords don't comply with the ordinance? And then who will be enforcing this compliance with the ordinance for both parties?
So if the landlords fail to comply, they're subject to administrative penalties. It is a city code, and we can issue administrative penalties if the landlords fail to comply. And we can issue administrative penalties up to $25,000. The enforcement would be done by the Community Development Department Code Enforcement Division. So again, it's really key that landlords comply because they are subject to those administrative penalties.
The next question is, how will landlord and tenants know when the state of emergency is lifted? And does the city need to take any formal action to end the moratorium ordinance?
So this moratorium is consistent with the governor's order, and that's currently scheduled to end on May 31st. So we won't have to do anything formally to actually lift this, but again, we'll probably post some kind of notice to make sure that people are aware that we are going ahead and lifting it consistent with the state. That would also be true if the governor's order should be extended. We would make sure to let people know that it's been extended as well. And the other dates would follow, the 120 days and everything else would follow if it was extended.
Great, thank you. And then the next step would be, once the ordinance is lifted, what are the steps required of the landlord and the tenant after that state of emergency?
Well, again, the tenants have 120 days to make sure that they pay any unpaid rent. So they would need to make sure that they work with the landlord to repay that. And that would give them up to about September 28th to handle that. So that's probably the most important factor, is making sure that there's some arrangements for making sure that the unpaid rent is covered.
Great. And then lastly, what recourse does the landlord have if the tenant fails to pay the rent that is due during that 120-day period after the end of the state of emergency, and who enforces that?
So Cheryl, would you like to address that one?
Sure. So, if a tenant has now not followed the ordinance and they haven't paid the back rent, it's up to the landlord to decide if they're going to proceed with eviction proceedings. They have to follow the state law providing notices. We hope that if it's a matter of they need more time to pay the rent, landlords might work that out with their tenant. But again, it's between the landlords and the tenants after the ordinance expires to determine what they're going to do if there's still unpaid rent.
Great. Thank you, panelists. And then let's move on to the next slide. We wanted to go over the 30-day review and survey process that's currently underway. As part of the City Council's adoption of the commercial eviction moratorium, they requested that staff also evaluate the impacts of the moratorium over the next 30 days. So as part of this process, we have released a survey that's open until Friday, April 17th. It's currently open now. It can be found both on the Economic Development webpage and the Tenant Protection Program webpage. There's a link shown here in the PowerPoint. It's available in multiple languages, and we will use this information as well as additional data that we're collecting in the community to return to the City Council within the 30-day review period on May 5th to provide updates on how the moratorium is impacting the community and its outcomes. Next slide. And then we wanted to highlight the different contact information for any assistance that's needed under the moratorium. So the Tenant Protection Program, here's their phone number, email, and website if you have questions about the moratorium and its carrying out specifically. The website also has frequently asked questions and forms that can be used by tenants and landlords. Secondly, we wanted to highlight that there are business assistance helplines out there if there's questions on resources available to businesses. And the city itself, we have our small business line, and we're happy to help with any questions that come up as well. And then turning it back over to Michael Jasso, our Assistant City Manager.
First of all, thank you to the staff of the Office of Innovation and Economic Development, as well as Cheryl from the City Attorney's Office for helping to pull this together. To all our residents, businesses, and property owners, we hope that you find the information that's been presented today helpful. As was pointed out when we first started, we're hopeful that we will be able to do a number of these webinars moving forward into the future. Many of those we expect also will be live, which will allow real-time participation by some of our viewers. But with that, I close the webinar, and we're all in this together, and we know it's a difficult and stressful time, but together we'll make it through. Thank you.
Thank you.